Hello everyone, welcome to A-Level Law Help. In this video we are going to look at the crime of murder. Now this is for AQA courses but is also relevant to other A-level courses. To begin with, we will start with a definition and then we will simply break the offence of murder down by using our definition. Murder is a common law offence and was defined by Lord Coke in 1797 as an unlawful killing of a reasonable person in being under the King's peace, with malice aforethought. We will start with the actus reus elements of our definition. For there to have been a murder, the defendant must have killed a reasonable person in being. The victim must have their own separate existence from the mother and have an independent circulation. Thus the killing of a fetus is not murder. In Attorney General's reference number 3 of 1994, the defendant stabbed his pregnant girlfriend. She recovered, but the child died after being born because the child was born prematurely as a result of the stabbing. It was held the defendant was not guilty of the child's murder, as the child was not in being when the mother was stabbed. Another thing to note is that a person who is brain dead is not in being, and therefore a doctor switching off a patient's life support machine is not murder. And the case for this is Malcorech. The next area of the actus reus involves the person being killed under the King's peace. This means that the killing of an enemy soldier during a time of war isn't murder. This is unlikely to be an issue in A-level questions. The final element of the actus reus we will discuss is causation. I will make a whole video dedicated to causation soon, but for now I will give a brief overview. In A-level criminal law, causation has two stages. First is factual causation. This uses the but-for test from R. v. White, but for the defendant's actions, would the result have happened? If yes, then they are not liable. Second is legal causation, which asks whether the defendant's act was a significant and operative cause of the result. In R. v. Kimsey, the court said it only has to be more than a slight or trifling link. The chain of causation can sometimes be broken by a new intervening act, known as a novus actus interveniens. This could be an unforeseeable act of a third party, an unusual act by the victim, or a natural event. However, medical treatment will not usually break the chain unless it is so independent and potent that it becomes the main cause of death, as in R. v. Cheshire. Finally, we apply the thin skull rule from R. v. Blow, which means you take your victim as you find them, even if they have a hidden weakness. Overall, causation ensures that liability is only imposed when the defendant truly caused the harm, but it also makes sure that vulnerable victims are still fully protected. So now we will look at the mens rea of murder. This is the mental element of the offence and is quite simple. The defendant must intend to kill or intend to cause GBH. This means it must be his aim to kill or seriously injure the victim. He desires it and he sets out to achieve it. In Vickers, a man broke into a sweet shop and attacked the elderly shopkeeper, who later died from her injuries. The court ruled that an intention to cause grievous bodily harm was sufficient to satisfy the mens rea for murder. This case confirmed that murder does not require an intention to kill, only an intention to cause really serious harm. So that is all for murder. If you have any questions about anything A-level law related, feel free to leave them in the comments, or follow me on TikTok and drop me a message. Thank you for watching. Please like the video if you found it helpful and subscribe for more A-level law content.